120 WPM English shorthand dictation. Be ready for it. Start. Para. To be non-compliance of regulation 81 in bracket A of the 1976 rules, which enjoins due observance of the principles of natural justice. Full stop. In this connection, Article 14 of the Constitution of India may also be referred, which clearly postulates that authority competent to pass orders is required to record reasons, which is one of the principles of natural justice governing exercise of power by the administrative authority. Full stop. It is well enunciated in various decisions of the High Court and the Apex Court that the disciplinary authority has to apply his mind to the record apart from the finding recorded by the inquiry officer before coming to the conclusion whether the charge of misconduct has been proved against the delinquent. Para. Merely asking the petitioner to submit an explanation in my opinion is not sufficient where it is proposed to impose a major punishment. Full stop. There are two kinds of hearings, a personal hearing and second non-personal hearing. Full stop. When it is proposed to impose a minor punishment such as withholding of increments or a fine or warning, a non-personal hearing would suffice. Full stop. In a non-personal hearing, all that has been done is that the delinquent employee is issued a show cause notice to which he gives a written reply, and on that reply the punishment is straightway imposed giving reasons. Full stop. In such a case, it is not necessary to hold a full-fledged oral inquiry, giving the concerned employee an opportunity of producing his witnesses and cross-examining the witnesses against him. Full stop. However, when it is proposed to impose a major punishment like dismissal, ordinarily a full-fledged inquiry must be held. Full stop. This is because a major punishment not only has very serious consequences upon the employee but would adversely affect the family. Full stop. Hence, the law imposes a stricter and elaborated procedure requiring a full-fledged oral inquiry in cases of major punishment. Full stop. In such cases, it is ordinarily necessary for the employer to issue a notice of the employee indicating the date, time and place of the inquiry after appointing an inquiry officer. Full stop. On the date and time fixed, the witnesses against the concerned employee is required to be examined ordinarily in his presence, and he must be given an opportunity to cross-examine them. Full stop. Para. Coming to the aspect of observance of principles of natural justice, in the instant case it is explicit from a perusal of the inquiry report that no date, time and place was fixed by the inquiry officer as stated herein above. It would crystallize from a perusal of the inquiry report that the disciplinary authority did not reckon that the inquiry officer did not fix any date, time and place, and no witness was examined by the inquiry officer. Full stop. The apex court has repeatedly emphasized for observance of the principles of natural justice in Mingla's T Estate versus their workmen AIR 1963 SC 1719. The Supreme Court propounded in clear words that it is an elementary principle that a person who is required to answer the charge must know not only the accusation but also the testimony by which the accusation is supported. Full stop. He must be given a fair chance to hear the evidence in support of the charge and put such relevant questions by way of cross examination as he desires. Full stop. Para. It is to be noticeable that Honorable Supreme Court, while laying down the law that in contempt jurisdiction no positive mandatory direction can be issued outside the scope of the order which is being alleged to have been violated by the authorities, has elaborately observed therein that the purpose of contempt jurisdiction is to uphold majesty and dignity of the courts. Full stop.